Good morning, counselors. We're here this morning to hear arguments on the case of New York State Rifle and Pistol Association et al. V. Kevin P. Bruin. Petitioners, would you please introduce yourselves to the court?
My name is Riley Grant.
My name is Cameron Rose.
Thank you, counselors. We're going to begin with a series of questions that speak to the primary question of this case, notably the protections of the Second Amendment. To begin with, what does the Second Amendment protect?
Thank you, Your Honor. The Second Amendment protects the rights of citizens to bear arms in order to protect themselves. They can do so by either being a member of a militia, which is viewed by the founders as being a regular citizen. The individual can also protect themselves in or outside of the home with any bearable arms.
Thank you, counselor. Why did the framers include the Second Amendment in the Bill of Rights?
The framers included the Second Amendment in the Bill of Rights because they believed that the right to bear arms was essential for the lives of free men. The framers also wanted to allow the people of the country to protect themselves and the country itself from tyrannical governments. In a quote from Federalist Number 29 written by Alexander Hamilton, the Second Amendment appears to him the only substitute that can be devised for a standing army and the best possible security against it if it should exist. One of the main reasons for the founding of the United States of America was to escape tyranny and the rule of Great Britain, and the Constitution and Bill of Rights were created to safeguard from corrupt government. This is why they would include the Second Amendment in the Constitution.
Thank you, counselor. What, if any, are the limits of the Second Amendment's protections?
Your Honor, the Second Amendment limits the usage of weapons modified beyond reasonable doubt, such as the sawed-off shotguns mentioned in McDonald versus Chicago. Furthermore, the Second Amendment's protections do not apply to those with a criminal history.
And what weapons does the term arms include?
Yes, Your Honor. So the term arm includes any object that is bearable, even if the technology is not yet around. This is due to Catano versus Massachusetts, which ruled that the Second Amendment extends to all bearable arms that were not yet envisioned by the Founding Fathers. This is to ensure that even if certain technologies, such as the stun gun in the case of Catano versus Massachusetts, could be considered bearable and allowed by the Second Amendment, even though the technology of a stun gun was not around during the time of the founding of the Constitution.
Thank you, counselor. What is the difference, if there is any, between the verbs keep and bear?
Yes, Your Honor. The verbs keep and bear are both very similar in nature to each other, but they kind of go together to provide a two-pronged definition of what it means to possess a firearm. So the word keep means to possess, so therefore that means any ownership of a firearm. And the word bear means to equip or use a firearm. So if we combine these two together, the ownership of a firearm means to possess it and to equip it or use it if necessary.
Thank you. What is a militia, and why did the framers refer to it in the Second Amendment?
In the context of the Second Amendment, and as commonly used in the era of the founders, the word militia refers to any person or any citizen of the United States that utilized the right to bear arms. In Federalist Paper number 46, written by James Madison, he is quoted as saying that the militia is amounting to near 500,000 citizens with arms in their hands, officered by men chosen from among themselves, and conducted by governments possessing their affections and confidence. As evidenced by this quote from many others and the framers used in the framers' generation, the word militia did not refer to an organized military force. To say that this is what it means would narrow the protections of the Second Amendment and would greatly dishonor the original intentions behind the creation of the amendment itself.
Thank you. How should courts determine if gun control regulation is considered long-standing?
Your Honor, the court should consider if a regulation is long-standing, if it can hold a scrutiny when necessary, and to be applicable to be used as precedent in future cases. An example of this would be the United States versus Heller, which has been used as precedent for many cases and is commonly referred to in debates among the Second Amendment. If a case can uphold the scrutiny provided by the state and can be used as precedent to describe a relationship, it should be considered long-standing.
Thank you. And what is strict scrutiny, intermediate scrutiny, and rational basis review?
Your Honor, there are 3 levels of scrutiny which can be used at varying levels in court cases decided upon the basis of the court. So the first and highest level would be intense scrutiny, and this is applied when a supposed law or a challenged law breaches a core value of an amendment. This, an example of which would be in the First Amendment, the right of the press and media. And so this is used at the highest level of cases, and on top of being validating a core law, it also has to be the strictest and most least regulatory way in order to maintain that the citizens hold a majority of their rights. The second level is intermediate scrutiny, and this applies when a core amendment or value of this amendment is in a part violated, but it's more a means to an ends rather than an absolute definition. And then you have the final version of scrutiny, which is the review basis, and this basically establishes that a government law just relates to a common problem of the government.
Thank you. Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Yes, Your Honor, there is a distinct difference. So open carrying a firearm means that the owner of the said firearm is brandishing out in public or carrying openly. This can be seen in Virginia, where citizens are allowed to openly carry rifle platforms. The concealed carry aspect, which you had mentioned, is referring to when an individual that owns a firearm conceals or hides their firearm on their body. An example of this, which is a handgun in most cases, is concealed in a person until they need it to pull it out and use it effectively.
Thank you. How should the court consider the public safety implications of licenses to carry firearms?
Your Honor, the court must consider the background of those that are applying to get licenses to carry firearms. Both Brandon Coach and Robert Nash were two men with absolutely no criminal history. If, however, a person that applied for a gun license had criminal charges on their record, then that would be a situation where the court must consider the public safety implications. If, however, there are no criminal charges on their history, then there should be no concern until proven otherwise.
Thank you very much for your answers, counselors. We're going to take a brief recess and reconvene for the reading of your briefs.
Good afternoon, Your Honor. My name is Riley Grant. I'm here with my co-counsel, Cameron Rose. She will be reading on the side of the petitioner the facts of the case for the New York State Rifle and Pistol Association versus Bruin.
In New York, a person seeking to conceal carry a firearm must acquire a license from the state. In order to get the license, one must show a special need for self-protection, and the state will determine whether or not to grant the person that license. Robert Nash and Brandon Coach, two law-abiding citizens with no criminal history, applied for the license in the state of New York for self-defense purposes and were denied because they did not demonstrate a special need. The two sued Kevin P. Bruin and Justice Richard McNally with the help of the New York State Rifle and Pistol Association, stating that there was no proper cause to deny them the licenses.
Your Honor, I will now be reading the summary of argument. So due to the court's previous decision based on the New York penal law, an individual's right is violated to bear arms for self-defense. As established by the District of Columbia versus Heller, the Second Amendment establishes that two spheres of influence are needed for the Second Amendment. The first is the overseeing of a well-regulated militia established by the United States versus Miller, which establishes militias and interstate commerce. The other sphere is the use of firearms to protect oneself, which establishes that the Second Amendment protects an individual's right to possess a firearm unconnected with service to a militia and to use that arm for traditional lawful purposes, such as self-defense within the home. The court ruled that the handgun ban was unconstitutional, as the ban severely limited the impact at which a law-abiding citizen could protect themselves in their own home. This right was expanded due to the interpretation that bearing arms included carrying firearms outside the home. This ties back to one of the core values of the Second Amendment, self-defense, and shows that the need for intense scrutiny while viewing the law is necessary. The court must move to eliminate this law and rule it unconstitutional.
As determined in District of Columbia v. Heller, one must look to the historical understanding of the Second Amendment in order to determine whether or not the Second Amendment has been violated by a particular law. The Constitution states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In Federalist Number 46, written by James Madison in 1788, the term militia is described as amounting to near 500,000 citizens with arms in their hands, officered by men chosen from among themselves, and conducted by governments possessing their affections and confidence. This definition of the word was widely understood in its original context. Thomas Jefferson, decades later, confirms this explanation of the term in 1811 in a letter to de Tracy, stating that the militia of the state, that is to say, of every man in it able to bear arms. This is how the term was commonly used in the founders' lifetimes, and it is how it is meant to be interpreted in the Constitution. In District of Columbia v. Heller, the Supreme Court agreed that historically, militia was a term used to describe the citizens of the United States who utilized their right to bear arms. To ignore this definition of the word is to ignore the meaning of the Second Amendment as it was intended to be applied to the citizens of the United States under the Constitution. Furthermore, to use the modern interpretation of the word militia, one must limit the protections of the Second Amendment to only those a part of an organized military force, directly contradicting the original reasoning behind the section of the Constitution, the protection of the people. The Second Amendment was designed to safeguard the rights of the people to defend themselves, and this intention dates back to before the conception of the United States. It is essential to reflect upon common law ideologies in order to understand where the Founding Fathers established their thoughts on government and law. Many philosophers that the founders drew inspiration from for the writing of the Constitution believed that the right to bear arms for self-defense was essential to the lives of free men. Cesar Beccaria wrote in an essay on crimes and punishment in 1764 that laws that forbid the right to bear arms serve rather to encourage than to prevent homicides, for an unarmed man may be attacked with greater confidence than an armed man. Beccaria makes the point that free men must be able to arm themselves for their own safety from crimes and violence. One concealed carrying a weapon in public is a clear example of where this thought would be applied to today. Another important influence on American government was William Blackstone, an English jurist. Blackstone's commentaries provided the same beliefs as Cesar Beccaria from an English perspective. He stated that the right to bear arms was one of the fundamental rights of Englishmen. Blackstone's commentaries were clear in their support of the right to keep and bear arms. One of the essential points made on the subject was that when the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction. America was established on the idea of liberty and freedom for all men in the country, as is stated throughout the Bill of Rights and the Constitution. The NY Penal Law is a prime example of governments attempting to limit the rights of the people when it comes to bearing arms. Founding fathers such as Alexander Hamilton were in support of this right, and he states in Federalist Number 29 that the right to bear arms was the most natural defense of a free country, and that it would appear to him the only substitute that can be devised for a standing army, and the best possible security against it if it should exist. Not only was the Second Amendment designed to allow citizens to keep themselves safe from danger, it was also designed to allow them to defend themselves from governmental tyranny. All of these beliefs were carried into the creation of the Constitution and thus the Second Amendment. The right to bear arms in order to protect oneself is a core value of the amendment, and these origins cannot be overlooked.
So while looking at this case, we have to establish what level of scrutiny must be applied in the New York State Rifle and Pistol Association versus Bruin. We must review what scrutiny is. The court has always upheld the belief that the scrutiny shall be applied on differing levels based upon the interpretation of the relationship between the law being challenged and the Constitution. Typically, intense scrutiny is applied to a law in place interferes with a core right of an amendment. In order for this law to be ruled constitutional, it must be the least restrictive way to enforce the law. One of the earlier rulings that applied to this scrutiny was United States versus Miller, which upheld a law designed to specifically target the regulation of sawed-off shotguns through interstate commerce. Intense scrutiny was used since part of the ruling mentioned how a sawed-off shotgun was utilized by a militia, which is a core value, and the fact that the law was the least restrictive way to enforce the law. Another level of scrutiny that is applied to a lesser level is intermediate scrutiny, which is defined as the government need not establish a close fit between the statute's mean and an end, but at least establish a reasonable fit. This is from the United States versus Chester. This allows for a statute that is partially related to a core value to be scrutinized but at a lesser level to where the restrictions set in place are less in value than those enforced by intense scrutiny. The final level of scrutiny is rational basis review, which is used to prove if a law is related to a government issue and is only used if a fundamental right is not being violated. An example of this is Gallagher versus Becerra, which upheld a law that allowed peace officers to carry firearms on school campuses because it was relevant to a government issue and did not violate a fundamental right, such as the Second Amendment. So with reviewing these three different standards for which each case should be applied, it is safe to assume that the case of New York State Rifle and Pistol Association versus Bruin should have intense scrutiny applied to it. This is due to two different subjects: the question at hand and precedent. To address the first issue, the standards of intense scrutiny must be reviewed and applied in this case. It is established that this level of scrutiny is determined appropriate if the law being questioned violates a core right of an amendment. In this case, involving the Second Amendment, some core values would include being involved with the militia and caring for self-defense in and outside of the home. The second part of intense scrutiny is that the law in question has to be the least restrictive measure in place. With this establishment out of the way, the next step is to determine whether a case of similar nature had been intense scrutiny applied to it and its outcome. Two of the most glaring cases that embody this ideal are the District of Columbia versus Heller and United States versus Miller. Both cases offer differing rulings when it comes to intense scrutiny, but allow for more important insight to be determined after viewing both of them. In the case of District of Columbia versus Heller, intense scrutiny was used to determine whether a case in the District of Columbia involving handgun was constitutional. This law was written as a total ban on handguns, and was the only way to legally own one was to receive a 1-year license from a police chief. On top of this, the handgun had to be unloaded, disassembled, and locked up in a safe. The court ruled that the law was unconstitutional because it violated a core right of the Second Amendment, the right to self-defense. It also went against the least restrictive measure, as it seemed that the law restricted a vast majority of citizens from receiving a handgun license. Another case, United States versus Miller, upheld a law banning sawed-off shotguns was constitutional. This is due to two primary reasons, being the least restrictive and pertaining to a militia. The law at hand bans all sawed-off shotguns, a modified firearm that is determined by the court is not a regularly related by a militia. Because of this, the law does not infringe a core value of an amendment since the firearm in question is not related to a militia. The other reason this law was ruled is because it is the least restrictive way to enforce the law. Since the sawed-off shotgun is modified, it isn't sold to the regular public and is instead modified by the owner itself or another distributor after the initial purchasing. Because of this, a vast majority of firearm owners will never own such a weapon, and since the original weapon wasn't produced in this manner, the law is the least restrictive way around this issue. While each case ruled differently by using intense scrutiny, the same basic principle applies. If a core right of amendment is violated, such as the right to keep arms inside and outside the home, then the law in question is unconstitutional. The other is if the law is the least restrictive, which in this case is the most restrictive since a vast majority of citizens are unable to receive a handgun license.
The Constitution of the United States is the supreme law of the land, making the power of the Second Amendment triumph over the power of the New York penal law that is being questioned in this case. According to McDonald v. Chicago, 2010, the right to bear arms specifically for self-defense under the Second Amendment is relevant to the states because of the 14th Amendment. The first section of the 14th Amendment makes clear that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, one of these privileges being the Second Amendment's right to bear arms. The amendment also describes citizens' rights to due process, which was violated in this case because states may not deny a person any legal right that a citizen of the country possesses. The NY penal law infringes upon two constitutional amendments, and to keep this law in place is to allow the states to overrule the fundamental liberties of the people of America, as stated in the Constitution.
So one of many arguments that the respondents will argue is that the need for a handgun was never envisioned by the Founding Fathers, and therefore a handgun should not be allowed to be distributed. The idea couldn't be further from the truth, as ruled by Catano versus Massachusetts, which states that stun guns cannot be banned under the Second Amendment. This is due to the court finding that even though technology wasn't around during the time of the Constitution, that the founders left room for bearable arms created in the future. With this in mind, we can relate the technology and innovation to handguns since it is considered a bearable arm. With this in mind, it is easily assertable that the handguns are covered under the Second Amendment even if they were not around during the creation of the Constitution. So the wording of the Second Amendment is kept very brief and non-descriptive, which is what allows for it to remain up to an individual's interpretation. The interpretation of certain words such as bear and keep are extremely close in definition but are extremely debated over. So according to the Webster's Dictionary, bear means to be equipped or furnished with something, while keep means to retain in one's possession or power. While the wording may be different, they both bolt down to being a two-pronged procedure to having an object in one's possession. To keep arms means to be in possession of such a weapon, and to bear it means to use it if a situation requires it. This idea is asserted by the District of Columbia versus Heller, which ruled that possessing a firearm outside the home is necessary, since the need to defend oneself may suddenly arise in a host of locations outside the home. This, in combination with the word keep and bear, used constantly in the same sentence, provokes the thought that these two words complement each other in a two-pronged definition of what it means to own a firearm.
To conclude, NY penal law violates both the Second and 14th Amendments. The state of New York infringed upon the guaranteed rights of Brandon Koch and Robert Nash when they denied them the licenses to conceal carry a handgun. As stated in the Second Amendment of the Constitution of the United States, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Yet it was in this case, dishonoring the original meaning of the Second Amendment and the beliefs of the founders. The other part of the Second Amendment is the right to defend oneself, inside and outside of the home. This right allows an individual to keep and bear arms, which is a two-pronged definition to allow someone to possess and use a firearm. The right to defend oneself with technology that the founders didn't imagine is also protected due to Catiano versus Massachusetts, which cited that a stun gun and any other bearable arm that is reasonable is allowed under the Constitution. Another aspect that must be addressed is the level of scrutiny that must be applied, which, after reviewing the different standards and requirements, is intense scrutiny. This establishes that a law must not violate a core amendment and be the least restrictive way to enforce it. With this in mind, NY penal law is unconstitutional because it violates the Second Amendment right to bear and to keep arms inside and outside of the home. The possession of firearms to a militia according to the historical precedent and from intense scrutiny. To conclude, the Supreme Court must determine that the NY penal law in this case is unconstitutional because of the violations of both the Second and 14th Amendments and previous decisions made by the court. Thank you for your time.